BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello, ladies and gentlemen. Welcome to Heritage TV, the Legal Hour show with BWF Solicitors. I hope you are all doing well. As you saw at the start of the program, this program is proudly sponsored by BWF Solicitors, Victon Estates Limited, and Eagle Heights International School. Today, we are going to talk about getting a child arrangement order. And with me today is our usual guest, Lawyer Eunice Achampong. Let's welcome Lawyer Eunice Achampong. Hello, Lawyer Eunice.
Hello, Vicky. How are you?
I'm fine, thank you. And how are you? How was your week?
Oh, busy. And I think that, of course, as usual, it is expected. So we thank God for the fact that we are still in employment, as they say, meaning I've not had it. So.
I know you started your week with going to court. You've been very, very busy.
Oh,
that's amazing.
Yeah, that was on the Tuesday that we spoke, isn't it? Yes.
Right. Good. Now to the topic, getting a child arrangement order. Lawyer Eunice, what is child arrangement order?
Okay, so for our listeners who may be listening to us, maybe somebody may already know what a child arrangement is, but for the benefit of those that may not know what a child arrangement order is, this is an order that is given by the family court, and it's usually will have in the arrangement for which a child whose parents may be separated for one reason or the other should live with. So they state in the child should live with parent A, and then maybe parent B will have them on the weekends or during holidays or for any specified period of time for which the court will agree. So it would arrange and state clearly who the child should live with for which periods of time, which is when, and then basically how the arrangements will be processed or how it will go on. And sometimes you may not have direct access. So if the parent who is applying or the person who is applying has said to the court, do you know what, I want to be able to see and have that physical contact with the child, they may not necessarily grant that physical access, and therefore sometimes the order may be indirect, and so they can state that the child should have just telephone contact or just video contact with the child rather than a physical or face-to-face contact. So yes, this is an arrangement which the court will usually agree to, but first and foremost, there are processes to be followed before you can even apply to the court for such an order. And as the show goes on, obviously, I will explain more and more about how you can apply for such an order as well.
Ladies and gentlemen, if you've just joined in or tuned in, this is Heritage TV's The Legal Hour show with BWF solicitors. We are talking about getting a child arrangement order. If you would like to contribute to the program, please send your questions via our social media handles, Facebook, YouTube, Periscope, and we'll be able to, delve into your questions. Back to you, Lawyer Eunice. Can anyone at all apply to the court for such an order?
So in cases like this, usually you would have a parent apply. So that could be the biological parents of the child, it could be a step parent, it could also be a relative. So if for one reason or the other, the parents are unable to take care of this child, so maybe for instance, the parents have been convicted of a crime and therefore the child has nowhere to go but to a relative. A relative can apply for a child arrangement order, and then they will be granted such an order. But first of all, they would also need something we call a parental responsibility order that would actually give them that parental responsibility to be able to basically take care of this child as and when the child needs them. And the good thing about this parental responsibility order is that at least everything regarding the child's welfare and well-being will be taken care of by this relative. And so usually if the biological parent, the step parent, a relative of that child wants to apply, and sometimes you even have local authorities applying as well, because they might have a child in care. And so once that order has been given, it will actually allow that child to be able to live with that person and to be taken care of by that person as and when they need to. So sometimes it's also a good thing that as much as possible, people who want to apply for such an order will also get some legal knowledge or get some assistance as to how they can go about it and then what it will involve, because there are costs involved in making such an application. And sometimes if the other party is not willing and is not as dedicated to the cause, it may take a prolonged period of time. And so I think people should not underestimate the time it takes to get such an order, especially if the other party is very unwilling and is taking the time to prolong matters. And so sometimes when it comes to these issues, it is one of the things that the court wants both parties to be able to agree to even before they come to the court for any order whatsoever. So yes, in this case, anybody who is a relative or a parent or a step parent can apply to the courts for this child arrangement order.
All right. But is it mandatory to go to court before you get the order? That's the only way.
Yes, to get the order is given by the court. Even for
Okay.
the parental responsibility order, you can agree informally that the other party will be given parental responsibility, but even that, you will have to have it signed and witnessed at the court. So that's the main reason why it is called an order. And if you look at our Children's Act of 1986, this
Yeah.
is specifically stated under Section 8. So this is an order which is specifically granted by the court and no one else.
Right. Lawyer Eunice, how long does the process take?
So, as I was saying, it can take quite a long time if the other party is unwilling and is prolonging matters. I mean, if you have somebody who is willing and is able to agree to the arrangements that are in place, then of course we may be looking at some time between 6 months to a year. But where the other party is being unreasonable, and we also have to factor in the court's availability as well, they may not have it so easily. And so
Okay.
it could take a year, 2 years. I have a colleague who is dealing with one and is over 2 years now. And sometimes you're just thinking to yourself, is it worth going on and on if the other party is unwilling? And sometimes you even hear in the news, for instance, when there's divorce cases and you hear how long the case has been going on for, you're
Has
thinking
been
to
going
yourself,
on.
goodness me, how much money is being put into this thing,
Put
especially
into, yeah.
because if you are dealing with a party which is so unreasonable, you may need the assistance of a legal representative, and the legal representative will definitely be charging you for their time in court as well, and this is not cheap. So if you are going to do it with the help of a legal representative, you have to pay their cost as well. And it's one of those things that you have to factor in. And if you are thinking about the child and you're putting the child as the priority in all of this, I don't think that you should be thinking so much about how long it will take, but how you will be able to have that relationship with the child should be more of a priority than how long the process will take. Yes, it can be expensive, but like I said, if the child is your priority, you will do all that you can to be able to be in this child's life, as
Okay.
the order will give you.
Okay.
Yeah.
Okay. Lawyer Eunice, can you take us through the steps?
Yes. So, in obtaining a child arrangement order, sometimes you may see, and you will have to be able to go through a process called a MIAM. MIAM is simply mediation and information assessment meeting. So, in terms of this, the court is basically trying to aim for parents or parties to be able to agree to some kind of arrangement before coming to court. And so usually you would seek the assistance of a mediation team or a mediation center close to you. They would usually contact the other party. So the applicant is the person who would usually seek the help of the mediation team. And once they've had the meeting with the applicant, they will also contact the other party to see if it's possible for the other party to be able to come to some terms or arrangements regarding the child or the children. So if it is possible that they are able to agree to come to some kind of arrangement through mediation, then of course that will be one of the ways to resolve the issue even before thinking about applying to the court for an order. Also, because it helps the other party to be more, should I say, careful in the way that they deal with the children. So it's also one thing to say that you're not giving the other party the liberty to see the children, but also you have to think about the children and what the children would want and how they will be able to benefit from all of this. And so I always say that it is good to have both parties agree to something before even thinking of applying to the courts. Especially where the parents were never married and they've had the child or the children outside of marriage and things have gone pear-shaped. It's almost as if the children's wishes do not matter at all. But through mediation, they are able to see where they've gone wrong and how best to be able to also meet the needs of the children. And sometimes it's good to be able to sit down and have that talk. But where it is not possible to agree on something like an arrangement for the child or the children through mediation, then the mediation team will sign you off and say that you have attended a MIAM and you are applying to the court, or you would like to apply to the court for a child arrangement order. So that will be the first steps that somebody will take. And once you've taken that application, which is a Form C1, to the court, there's a fee that is also paid to the court to be able to make that application. And once the court has received your application, usually you would also have a statement that goes with it to say why you are applying to the court for this order. If it's to have that arrangement for the purposes of having contact with the child or having to be able to have the child live with you or to be able to have the child contact you, then of course that will be stated clearly in the Form C1 when you are applying. If the court receives your application, they will then contact the other party to also let them know. But if you're using the help of a legal representative, the legal representative will also inform the other party that you have applied to the court for a child arrangement order and that they are to seek legal advice in terms of the arrangement order application that you have made to the court. And usually they call them Section 8 orders. So if you have a legal representative, they would also inform the other party. In some cases, you may not have even the address or the contact details of the other party, and therefore you will have to fill in a Form C3 to the court to say that, well, you don't really have the contact details of this other party, and therefore it is going to fall to the court to be able to get the contact details of this other party and then serve them in that case, because you don't have those details to give to the court. And so once the court has forwarded these the details of your child arrangement orders to the other party, they would invite the both of you to a hearing. And that will be the first of many hearings, which will go on before there is a final order made. So usually you would have the first appointment hearing, and then you have all the other hearings that would take place if the court is supposed to look at how best to reach an arrangement with you and the child's mother or father. And they would also request that the social services, which is CAFCAS, produce a report. So they will have to assess the relationship that you have with that child, and then give a report back to the court to inform them of what they believe to be the best way forward for both you, the parent, and the child.
Okay, Lawyer Eunice, during this process, should the child live with their mother or father? And secondly, can the court order equal shared parenting? 2 questions.
Okay, so in this case, usually the child will be living with one parent if one other parent is making the application. So because the child will be living with one other parent, that means that the parent who is applying is saying, I haven't got any contact with this child, and I want the court to be able to make an order such that I will also be able to have this child live with me for certain periods of time. And usually the court will always have certain considerations when making such orders. And so in terms of whether they will allow the other parent to have equal, should I say, contact or equal living arrangements, that would depend on the considerations that the court has to take into place. So sometimes they will be looking at the child's age, they'll be looking at the child's sex, at the child's background. If the child is, let's say, a 3-year-old boy who is living with the mother, and obviously the court believes that with boys it's always good that they have a male figure in their lives, so that they will be able to obviously communicate with them as and when, and there are certain things they may not be able to communicate with their mother. Then of course the court will be looking at how best they can meet those child's need. And if, for instance, the child has not been harmed in any way by the father, because they are going to be looking at whether the child has ever suffered any harm through the parent, they'll be thinking about the child's best wishes and the child's feelings. And so all these things will have to be taken into consideration by the court. And if the parent is a hardworking parent who is just looking to have some sort of contact with the child, then of course every child is entitled to have both parents in their lives, regardless of how, should I say, how badly the other parent may term to view them, because usually these cases do not start on a good footing, and there's always something that comes out of the bag. But that's the good thing about having CAFCAS as well produce a report to the court, because that way the court is able to then have an objective view of the relationship the child has with that parent. And even if they don't really have a relationship with little children, there's always a bond. If the other parent has a bond with that child, the social workers are able to put that in their report. We see that the child is bonding with the parent, and when they are at playtime, they are constantly engaging and relating to what the child is saying and doing. And so all of this comes through when the social worker is writing their report. That is how the court is able to also make their judgment, because they have seen through the report that there is a certain level of bond, or there's a certain level of should I say attachment between the child and the parent, and regardless of the age, they would always say that, do you know what, it is for the child to have both parents in their lives. And I think the paramount thing for the court will be the child's best interest. They are always thinking about the child's best interest. And so if they believe that the other parent should have equal contact with the child, then of course they would grant maybe that the child should be able to see the other parent basically on certain weekdays if they're, for instance, both parents are living close together, and they're going to be thinking about a child's education as well. If both parents are living separately but within the same area, and the child is living between both parents at equal distance, maybe it could be that 1 week you spend with this parent, the other week you spend with your other parent, and they can alternate in that way. So depending on what the party who is applying to the court for the order has stated they would want to happen, the court will also look at their wishes and then the wishes of the child as well, to be able to come to a conclusion as to how and when and how long the child should be with the parent for. So it's all dependent on certain factors. Like I've said, the child's education, their feelings, their wishes, their age, their sex, whether there has been any harm suffered, the effect of them not having the other parent in their lives. Those kind of things will be considered by the courts when they are making their decision. And so it's not a one court fits all scenario for every case that goes on in the family court.
Okay, all right. Ladies and gentlemen, if you've just joined us, this is Heritage TV, it's the Legal Hour show, and today we are discussing getting a child arrangement order. With me is a representative from BWF Solicitors, lawyer Eunice Achampong, who is today taking us through the process, what it means, everything about the arrangement order. At this point, we would like to take a short break, and we'll definitely be back with you in a moment. Please stay tuned. Don't go anywhere.
BWF Solicitors, we take pride in our clients' service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station, for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Welcome back, ladies and gentlemen. This is Heritage TV, the Legal Hour show with BWF solicitors, and we are discussing getting a child arrangement order. With me today is lawyer Eunice Achampong, a partner lawyer at BWF solicitors. Eunice?
Hello.
Yes. I want to find out from you, can a parent stop contact?
So sometimes
Can they ask the court to stop contact?
Okay, so in terms of the child arrangement order, if the other parent wants to bring to the court the reasons why they believe that the other parent should stop having contact, then they need to apply to the court to vary the first child arrangement order that is already in place. So, for instance, if the first child arrangement order said, well, the child should live with their mother, but the father should only have the child on weekends. And it's the other parent has realized that maybe if the father is having the child on weekends and then on Mondays bringing the child home, and it's not to do with this other parent being in agreement with the child coming on Mondays, then of course they would have to ask the court to have the child arrangement order varied. So if it is the case that they've breached that first order, then of course this child arrangement order varied so that the child is able to be with this other parent for that period of time that this parent wants them to be with them for. So I think that, of course, they can have it varied, but within reason. So they should be able to have reason why that initial order should be varied in the first place.
Okay, right. Now, questions have started coming in. Oh dear. Lawyer Eunice, Amina is saying, that's a very long one, but I'll give you my best shot. Right. I have a daughter who is now 8 years old. I was previously in a relationship with her mother for about 4 years until we separated. Her mother refused for me to go and see our daughter and told me my name was not put on the birth certificate. So she was not my daughter. I know she's my daughter and would like to know if there's anything I can do before getting the child arrangement order.
Okay, so you have here a parent who was not married to the child's mother, and for some reason or the other, the name of the other parent was not put on the birth certificate. In cases like this, and it happens more often than not, you will have the child born and then the other parent is not on the birth certificate. And for this parent to say they want to be in the child's life and they want to find out how they can have their name put on the birth certificate.
Yeah.
That's one of the reasons why a lot of parents don't even have that amicable arrangement to even speak to each other even before they go to the court. And in this person's case, they can apply to the court for a parental responsibility order, like I was saying in the beginning, and that would give them, should I say, the authority or the responsibility to be able to say yes, they are the father of this child, and they can do it by agreement with the other parents, or they can apply specifically to the court for this parental responsibility order whilst applying for the child arrangement order. If they are able to agree, then there's a form that they can complete themselves and then take to the court for the court to consent or witness to. But if not, if the other parent is saying, no, I don't want you to have anything to do with my child and be gone, I don't want you near her for any reason whatsoever, then the other party should definitely apply to the court for a child arrangement order with parental responsibility to obviously have that responsibility given to them as the child's parent, so that they can be able to have that contact with the child, so the two can be done together. And so therefore an 8-year-old child, I mean, if he was in that child's life for 4 years and then for one reason or the other they have separated, they are no longer together, usually it will be for the reasons that we don't know, but that shouldn't mean that the child should also be affected by whatever the parents are going through. And so it's important that once they've made the application to the court, then the court will also consider giving the parent who is applying that parental responsibility, as well as arrangements as to how they would have contact with the child, or who the child will be living with, and when and how, and the rest of it.
Okay, all right. A question from is it Hamid? Before I read this question, you can see the studio lines on your screen if you want to call in to ask a question or contribute to the program. The mobile number to call me on is 075-9875-7767, and the studio lines are on your screen. So I would like to encourage all of you watching to engage in this discussion and let us know what you think. If you have any questions, we would love to hear from you. Yes, Laura Eunice, I have tried on many occasions to have access to my son. Every time I call his mother, she will allow me to speak to him, but will not allow me to pick him up, to take him out. I'm fed up with her attitude and want to find out if I can get a child arrangement order.
So, in this person's question, they're basically saying, I just want my child to be with me. That is what they're saying in essence. I don't know why the child's mother is allowing the father to speak to the child but not to see the child. I don't know if there's any issues of consent, because for me it doesn't make sense that you would let the child speak to their father but not let them see him.
Laura Eunice, it's very, very common. Very common. Even personally, I've had some colleagues at work who have been going through these things. Their grievance is that they will support financially whatever the child needs. They support the child. But when it comes to picking up the child and spending some time with the child, it's a no-no. The furthest they can go to is just a phone call. Wow. It's very, very sad. I know of some colleagues at work who have been through this situation. But you know what? One of them, I think they are partners, ex-partners, confided in a friend of his and told her that she's afraid the child's father will abscond with the child. That was one reason one of them made.
Ah,
So I don't
okay.
know the reason for not, allowing the child to spend time with the
Yes.
dad.
Yeah, yeah, yeah. And so, like you're saying, there are so many reasons why these mothers will not allow the fathers to see the child. And one of the reasons is absconding. And for absconding, obviously, we have something called prohibited steps order, which come under Section 8 of the Children's Act. So if you are afraid that this will happen, whilst applying for the child arrangement, just tell the court, please make sure you put in there
Sure.
the father is not allowed to travel
Loud
with this child outside
with
of
this
the
child.
UK without my consent. Because that in itself, if it's breached, is a contempt of the court's order, and you can be convicted of that. So it is very important that if you are afraid that something like that will happen, the court can
Mm,
put that in as a prohibited steps order so that the other parent does not do that. But in
mm.
terms of the question, there are so many reasons why the mother may also not agree to the child's father having physical contact. And usually, I think sometimes it's just a grievance as well. It's
Oh
because
yeah.
of what they went through in the relationship. So they're thinking,
Yes.
of course, what you did to me was not fair, and because of the grievances that they may have towards the other person, and so that has also affected the relationship in terms of the child as well. So in such a case, if it's a grievance that they have towards that person, then in no way would they allow the child to see their other parent, because they are thinking this person is a good for nothing. Why should I even allow them to even see my child? And it's one of those things that I feel, yes, the person has grieved you, but that was you. It wasn't to the child. So sometimes you also have to let the people who are in these situations look at things objectively. But it's
Mm.
also a sad thing that because they are in it together, so they can't look at it objectively. They are
Mm,
thinking
mm,
about themselves, and everybody's thinking about what they can
mm,
get from the other person. And like you were saying,
mm,
sometimes
mm.
the other parent will give money to the mother to be able to
To
care for this
take care
other
of the
child. They will
child.
buy
That's whatever
gifts,
they have to.
they'll do some shopping, they'll do all these other things just so that they can have some sort of relationship with the child. But then the mother would refuse. If it is the case that there has been some sort of abuse going on, like we were talking about last week, and so it can be physical abuse, but not just physical abuse, but
Yeah.
emotional and psychological abuse. If that is the case, with the Kafka's reports, they will always make sure that they look into the background of that person. So if there has been any police reports made, or if there
Right.
has been any cases, I mean, from the school potentially, of the child reporting that there has been any scenarios like that, the Kafka's reports will always pick those things up. So that will be picked up if there has been an issue beforehand of any sort of harm or psychological or emotional or physical abuse. These things will be picked up because they will also speak to that child on an individual level and assess the child individually, and then assess the child with their parent as well. So those are the things that the Kafka's report will also pick up. And
Okay.
that will also be stated in their report to the court. So all these other reasons, once the Kafkas have had an interview with the other parent and has realized, oh, it is grievances that the other party has, or maybe the other party is scared that the father will abscond with the child, all these things will come out within the assessment that the Kafkas or the social workers will carry out. And so usually you have this long report from the social workers and you're thinking, oh my goodness, this is long. But then as you read, you realize that because they've had to assess the parents individually and then also assess the child with the parent. And that is why they have written such a long report for the court to be able to make an informed decision holistically rather than just from a one-sided point of view. So yes, in this person's case, they are completely fed up, and I can understand that, because if you're doing all that you can to be in this child's life and you are being prevented from doing so, then of course you have every reason to challenge whatever the other parent is doing. And in this case, taking the first step will be to go to the Mayam. So if you have tried going to the mediation information and assessment meeting and they've said to you, well, we've contacted the other parent, she is not willing to come to an agreement through mediation, therefore you can apply to the court, then of course you can then go ahead and make the application to the court for a child arrangement order. And as I've said to you, the Kafkas will always produce a report to the court. So they will interview you, they will interview the other parent, they will interview the child. They would, interview both you and the child to see what the bond is like, what the relationship is like, and as much as possible, give an informed decision to the court. And sometimes they will also suggest what the arrangement should be for the parents and that child as well, which will in turn help the court. But at the end of the day, it is for the court to make that decision. They may choose to go with what the Kafka's report has suggested, or they may also make a different conclusion than what the Kafka's has reported back to them. And so that will all boil down to what the parents are capable of doing. And as I've said, the court will consider the child's best interest. That is paramount. So if the child is a 10-year-old or 11-year-old, that child will also have their own views, and they can also tell the social worker, yes, I want a relationship with my father. Maybe my mother is preventing me from having that relationship. So as much as possible, can you make sure that my dad is able to pick me up on the weekends or the rest of it? So if that child is a child who is capable of making their wishes and their feelings heard, the court will also consider these things, because they've reached an age where they can also make their opinions about such matters as well. So yes, of course, if you are fed up, definitely apply for the Mayam. And if it is not possible to make any arrangements through mediation, then of course go through the court application system. And then of course, like I said before, it is not one could fits all scenario. It may take longer to come to an agreement, because maybe the other party has so many other reasons why they don't want you to be a part of the child's life. And so yes, please take that into consideration, the time and the cost involved in making that child arrangement order as well.
Right. Whew. Laura Eunice, before I ask this final question from Miss Olori, if a child is insistent, let's say the child is with a mom, is insistent, he or she rather wants to be with a dad, would they interview the child and take the child's word? As the child is insisting, I'm not comfortable, I'm not happy living with mom, but I rather want to live with dad. How do they make that decision? Is it in the child interest? I know it's in the child interest, if I should put it this way, but would they take the child's word if the child is insisting, I rather live with my dad, who is not living with mom, but she would like to move and live with dad? How would this work?
So that will also depend on the reason why the child is saying this. And like I was saying before, there are certain factors that the court will consider. So if it is the case that the child has made their wishes and their feelings heard, the court will also have to consider whether the parents are capable of taking on that responsibility. So maybe the father works. The father is not capable of having the child with them 24/7. Obviously,
Right.
if that is the case, the court is going to say, because this parent is not capable of having this child on a full-time basis, we may not be able to grant the wishes of this child, I mean, as he wants it. And so there are different factors which the court will definitely consider. And if it is the case that because of the child's age and the background, they're thinking, okay, this child is young, they have made their opinion heard, but we as a court will also like to give the child the benefit of the doubt, to say that because maybe um, the parent has been, let's say, has been out of their life for a certain period of time, so they can understand why they are now making this assertion to be with maybe the father for that period of time rather than the mother. But a child will always need both parents, and so the court will also have to consider the fact that both parents will play a role in this child's upbringing. And like I said before, the Kafka's report will bring to the surface if there has been any harm done by both parents. So if the parent of the child, who is the mother, is living with the child and the child has made certain allegations that they have suffered harm from this parent, and there has been reports by the school and so on and so forth, the Kafka's report will bring those issues up. So if there has been any issues whatsoever, yes, the Kafka's report will bring this up. And if it is things that the child is also making up, obviously they will ask further questions, and social workers have a good way of probing to find out more questions. Trust me, if you have one in your life, you don't want to be near them, because the kind of questions they will ask for you to give them the answers that they want is amazing. And I would just say I have
invasion of
I've
privacy.
if you have social workers in your life, you'll be thinking, oh my goodness, how did I get to this point? So one thing I always say is that they are very good at their jobs, and they know how to do their jobs very well. And if they feel that this is something that the child is just saying to have his own way, that will be also made clear, within their report as well. So it would not be a blanket decision that because the child has said they want to be with their father, and so that is it. There are considerations and other factors that the court will consider. Like I said, they will have to see how capable the parents are, if there has been any serious harm. They will obviously take into consideration the child's age. If the child is almost 16, of course, then it means that they are thinking clearly about what they are saying, and so the court will have to consider their feelings and their background and age, and say, okay, if this is really what you want, then of course both parents are capable of looking after you. But if you have decided that this is what you would like, then maybe we will give it a 50-50 split, so that you can spend more time with your father than you were able to previously. And then as time goes on, if you feel that you want to spend more time with your father than your mother, then maybe you spend the weekdays with your father and then the weekends with your mother. So yes, the court can come to some sort of arrangement based on the child's wishes and feelings, but it's not a blanket conclusion. They will have to make those other considerations before they give their order, their final order.
Great, great. So going to Olori's question, can this child arrangement order be used in an immigration matter as evidence to regularize her stay?
In cases like this, of course, yes. The initial answer is yes. But as of 2019, there was a case where um, there was an immigration matter and the other parent was not willing to provide any evidence to the father for his application for leave to remain. And you know, when you're making an application as a parent of a child who is either British or settled in the UK, you need some sort of letter or supporting letter from the parent to say, yes, they have direct access to this child and therefore they are involved in this child's life. If that is not forthcoming and you haven't got any evidence to prove that you are in this child's life and you've got a child arrangement order, those arrangement orders are accepted by the Home Office. But because of this case, it was said that all family cases to be confidential. Family matters should not be taken as immigration matters, and so therefore, if
Okay.
they are supposed to be confidential, then you need the permission of the court to be able to use this as evidence in terms of your immigration matter. So, yes, you can use it, but you need to have the permission of the court to be able to use that evidence in an immigration matter because they are separate, should I say, legal issues. And so, what belongs to the family court does not go into immigration, and what you term to be as immigration matter will not go into the family court. So unless you ask for the court to give that permission, then you can use the evidence that you have as and sort of evidence to say that yes, you have that involvement in that child's life, but it has to be direct. It cannot be indirect access. So if the court has said you can only have telephone contact or video contact, that will not be good enough in an immigration matter because then you can't meet the requirement. The requirement is that you have direct access, which is you are able to physically have face-to-face contact with this child. Yes, with this child rather than just telephone conversations or video conversations. So it's important that the child arrangement order that you have gives you that direct contact rather than indirect contact to be able to also use the order as evidence in an immigration matter. So yes, to answer that question, yes, they would be able to use such an order in an immigration matter.
So, Lawyer Eunice, those men, if I should say, who are being refused access to their children, what do they do in this matter? As regards to their immigration application. The only thing I can say is that you try whatever means you can to sweeten the other partner up, shopping, treating her nice. When she least expects it, you say, I've transferred £500 into your account. Just get something for yourself. Do you agree with me? I feel that could be one of the factors.
Completely where you're coming
just
from.
To let them loosen up a bit. That I mean no harm. I just want a physical contact with my child.
Yeah. I completely agree to what you are saying because I mean we're all human beings, and if you've been with somebody for a certain number of time, I'm not saying that you know everything about that person, but you should know how to soften that person up. You should know how to basically make that person feel like, do you know what, you're not taking me for granted, but you actually do care about me in a way. So if you can get to good terms with that person, why not do that? Because sometimes I'm thinking to myself, yes, you may not want to be in a relationship with that person. That's fair enough. But that shouldn't stop you from being a normal, good human being. And I think everybody is capable of some kindness and some form of goodness. And if you know that it will benefit you, then obviously go the extra mile, because at the end of
Go
the
the
day, it
extra
will
mile.
benefit. Yes, it will benefit you yourself. So just do what you have to do and just be nice. Maybe you have to go the extra mile a bit, and then you have to maybe put more effort into it than you would usually do. Then of course do that. If it's to do with the fact that maybe you need the child's birth certificate and the child's passport to be able to make the application, yes, say, do you know what, I just wanted to let you know that I've put some money in your account for Philip, and maybe if there's something left over, you can use it to get something for yourself, or I've put some extra money in there for his shopping and stuff that he needs, so you don't need to worry about all of that. I mean, if you are doing it regularly and it's not just spontaneous, like you do it every
Spontaneous,
once
yeah.
a year, then
Yeah.
of course, the person's thinking you're not serious. But if this is something that you are doing and you're saying to the person, hey, I want you to give this to Philip, and I want you to be able to also get something for yourself, then the person knows, oh, okay, I'm not in a relationship with him, but at least he cares about his child. And be polite. It doesn't hurt to be polite. Sometimes you may be giving money and the money will not help because the person feels like you don't even treat them as human being, and you're just giving them money. So sometimes it's good to be polite, be should I say, show care in the things that you do.
But Lawyer
Otherwise,
Eunice, on the side,
yes,
yeah, on the side of the women, I must also say that, look, like we were saying, a man can go the extra mile, do
yeah,
whatever he can, but the
yeah,
woman will not budge. Why? Because she's using that as a form of punishment. Why did you leave me? So whatever you do, you can do whatever you want to do. I'm not going to give in. What advice do you have for
that's
such
some
women?
women. That's some women, and I think there are other women who will push you out of the door. And I've had clients who have said to me, "This woman literally threw me out of the house." So when you have cases like that, and you know that it is because of something that you did, and that's why she threw you out of the house,
She threw out,
um,
yeah.
then of course you know how to um maneuver and make sure that you are in the good books of this person. But in the case where
Okay.
the other party, who is the man, has left the relationship, and the woman has some grievance towards the fact that you
Yeah,
have
it's very
left
bitter.
the relationship and you have left me in this situation, and you did not even care about me and this child, and now you want to have some contact with the child, then I can understand the fact that the woman will want to withhold the child from you because of what you have done to her. And that's why I
Mm,
said,
mm.
usually in these reports, the Kafka's report will always make it known that there are some grievances, but that should not stop the child from having a relationship with their father. It is
Father.
important that every child has a relationship with their father. So it might be that the contact may start as indirect. So it could be that they will say maybe the child has not been in, I mean, the father has not been involved in the child's life for a period of 2 to 3 years. And
Yeah.
so let's start it gradually. Let's start with telephone contact, and then let's give it a
Mm.
period of 2 or 3 months. And then after that, we will try the physical contact. Maybe they will meet at a center, a community center, once a week.
Okay. Okay.
And if that progresses, then we can go on and then have the contact varied so that they will have more physical contact rather than indirect contact. So they can start it off gradually. The court can start it off gradually, and then it will keep going on and on and on from indirect to direct contact, so that at least that child will be able to have the other parent in their lives. And so it depends on how willing the other parent is also willing to go. Because if they are not willing to come to any terms with the mother of the child, and they're saying, do you know what, you're a difficult person. If you're not going to allow me to see my child, then that's it. It depends on how willing the other parent is as well. So if they left the relationship for one reason or the other, are they also saying that they are willing to forgo the relationship that they would have with that child? That's another question that I will ask as well.
Right. Wow. Let me quickly acknowledge Onumorigba Onuoluwa, Angela de Campos May, also Temitope, and Abose Emmanuel Huesu. Thank you so much for your input. If I'm not able to mention your name, please forgive me, because our time is up. Lawyer Eunice, if anybody maybe it's the first time tuning in and watching you, would like to contact you, could you please give us your details and how to contact you?
So, as you said, I am Eunice, a champion of BWF Solicitors, and we are situated in London, very, very, very close to the Seven Sisters Underground Station. Our address is the 4th floor of Anna House, and it's 214 to 218 Tottenham High Road, London, and the postcode is N15 4NP. So N15 4NP. Our offices are opened from Monday to Friday from 9:30 a.m. to 6 p.m. And our office number is 0208 493 7340. So 0208 493 7340. My personal number is 075 35 81 3910. And just before I go as well, I just wanted to just give a quick update, and I think the next time I'll let Vicky have the video as well. In terms of our EU nationals and their family members who are living in the UK, we all know that we have up until the 30th of June 2021. So as much as possible, regardless of whether you previously were given 5 years residence card or you have permanent residence card, you still have to make those applications under the EU settlement scheme before 30th June 2021, just so that you do not become somebody they term as an illegal immigrant in the UK. So please, if you know somebody who has retained their right, or is a family member of an EU national, or is an EU national themselves, and they have not submitted their applications under the EU settlement scheme, please do make sure you share this video and make them aware that there is something called an EU settlement scheme that they can Google and apply for. Thank you, Vicky.
Wonderful. It's not a nice thing when you become an illegal immigrant. It's not nice at all. Thank you so much for that update. Ladies and gentlemen, as you heard, that is our lawyer, solicitor, and she's also a partner of BWF Solicitors, who today took us through getting a child arrangement order. As you know, this program was sponsored by BWF Solicitors, your number one law firm in London, and Victon Estates Limited, your property management company. You can contact them on 0744 8619 711. And finally, Eagles Heights International School. They are here to promote excellence in mathematics education. So if you need your child to do very well in their 11 class and in their A levels, please don't look any further than contact Eagle Heights International School. At the moment, they are doing virtual studies, and it's going very, very well for them. Please contact the team on 075 437 07121, 075 437 07121. I also want you to know that exactly at 2 o'clock, I'll be coming on again with Ama Cares. It's a charity organization that deals with child abuse issues. So 2 o'clock, I'll come back on, to have a discussion with one of their resource person. And I think at 4 o'clock, BWF Solicitors have a community law education program on their Facebook page. So at 4 o'clock, if you want to, get more insight about immigration and law, just jump on BWF Solicitors on their Facebook page at 4 o'clock, and you'll be very happy you did. On that note, Lawyer Eunice, would you like to join me to give our viewers a lovely wave to say goodbye, and we see you guys next week, Saturday at 12 noon. Bye from me and Lawyer Eunice. Take care and stay safe.
BWF Solicitors, we take pride in our clients' service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.